Yeah, I already record it.
Okay, thank you so much, Syami. Okay, siapa yang tak dapat boleh tune in. Kalau yang cepat ke lambat ke boleh playback lah. Forever. Sampai faham. Okay. Okay, for this privilege, we refer to section 126 of Evidence Act. So 126 provide for professional communication, which state clearly that no advocate shall at any time be permitted unless with his client's express consent. Express, bukan implied. Okay. To disclose any communication made to him in the course and for the purpose of his employment, as such advocate by or on behalf of his client, or to state the content of the condition of any document with which he has become acquainted, okay, in course and for the purpose of his professional employment, or to disclose any advice given by him to his client. Itu tak boleh, okay. No advocate, okay, tak dibenarkan. Dalam bahasa Melayunya, seorang peguam bela tidak boleh pada bila-bila masa dibenar, melainkan dengan persetujuan nyata kliennya mendedahkan apa-apa komunikasi yang telah diberikan kepadanya dalam masa dan bagi maksud dia digunakan hikmat sebagai seorang peguam bela itulah. So tak boleh lah dipakai ya. Close, okay, tutup. Explanation to this section clearly state that the obligation stated in section 126 continue even after the employment has ceased. Walaupun pelanggan tu, klien tu bukan lagi klien kita, kita masih bertanggungjawab untuk melindungi komunikasi apa yang telah disampaikan oleh klien kita kepada kita buat selama-lamanya. Okay, it cannot be disclosed unless you manage to get the express consent from the client. Okay, kena ada express consent. Kalau tak ada express consent, then cannot lah. Itu dia. Kena ada express consent. Semua faham? Okay. So this obligation continue even your client is no longer your client. Okay. So what's the purpose of having this kind of privilege? Sometimes, okay, prosecution would like to call a lawyer to come to the court to testify, a witness. So they want us to disclose everything. Okay, so the issue now, can we rely on certain privileges lah to protect us from being forced, being compelled to disclose the information? So we have section 126. Last week is about marital communication. This week only for solicitor. Okay, itu dia. You refer to section 127. This section 126 also apply to everybody. Okay, not only interpreters but everybody lah. The clerk, the servant of advocate, okay, jurubahasa dan juga kekerani atau perkhidmat peguam bela. Mereka-mereka yang bekerja di pejabat peguam tu tak boleh. Okay, budak-budak chambering pun tak boleh juga. Okay, budak-budak attachment pun tak boleh juga. Okay, itu dia pun tak boleh. So communication is protected. Not only lawyer and client but everybody are working within that firm. You must respect, okay, whatever being communicated between your client and to the firm. Not only lawyers but to the entire firm lah. Okay. Why? Why we need to have this privilege? Anybody know? Syami tahu tak kenapa kita ada this kind of privilege? Logic and common sense.
To protect the interests of the client.
Excellent. That's the answer. That's to protect the interest of the client. Abdul Had tahu tak apa lagi sebab? Abdul Had ada ke? Abdul Had? Ada. Adib ada? Adib Hanisa. Apa sebab kita ada ni? Privilege?
To preserve the information acquired by the client.
Apa dia?
To preserve the information acquired from the client.
Okay, excellent. To preserve the information given by the client. Thank you, Adib. Itu dia. Hazim ada? Hazim Akifullah ada? Ahmad Azim?
Ada, saya ada.
Kenapa kita ada privilege ni?
Because sometimes the client tend to tell everything and for the interest lah.
Okay. Thank you, Azim. Ahmad Ridwan ada? Ahmad Ridwan?
Ya, saya.
Why we need to have this privilege?
To disclose client private information, to feel to feel the client comfortable when speaking.
Okay, thank you. To make client feel comfortable to speak, yeah. That's the reason, Who else, Jarif ada? Muhammad Jarif, Mat Nasri ada?
Yeah.
Kenapa we have this privilege, Jarif?
So that the document that's secure does not taken advantage by other parties.
Okay, thank you, Jarif.
Yes.
Okay, it's correct lah what you say. We need to protect the information lah. Okay, if we don't have this kind of protection, nobody will come and see a lawyer. Okay, nobody will come and see a lawyer. Logic lah. So if nobody come and see lawyer, then there's no point in being a lawyer lah. Better we close down our business and do other things. Okay, so we need some assurance. Okay, every kind of profession, not only lawyer lah. Okay, they have their own protection. Semua ada profession. Macam doktor pun, nak jumpa doktor pun mesti ada maklumat tu tak boleh di-revealkan. Okay, kepada orang umum awam. Itu dia. Same thing. Okay. So when talk about this legal professional privilege, it's divided into two. Listen carefully. It's divided into two. Legal advice privilege, LAP, and litigation privilege, LP. When we talk about legal professional privilege, it's divided into two aspects. Legal advice privilege as well as litigation privilege. So we're going to discuss one by one. Legal advice privilege, LAP. What on earth is that? It's a legal advice lah. Nama pun legal advice. Legal advice privilege. Okay, legal advice privilege protect confidential communication between lawyers and their clients for the purpose of giving or obtaining legal advice. For legal advice privilege to apply, the communication in question must be of a professional legal advisor with the sole and dominant purpose of giving or obtaining legal advice. You refer to the case of Three Rivers District, okay, against Bank of England, okay, 2004, 3 Weekly Law Report 1274. So legal advice privilege is a privilege you give, okay, to a client. A client can come and see you, want to seek a legal advice. So whatever being advised, which is legal in nature, it should be protected under legal professional privilege under section 126 and 127 lah. Okay, itu dia. So dalam kes Three Rivers District Council against Bank of England 2004 3 Weekly Law Reports, Lord Scott clearly mentioned that. What do you mean by legal advice? Legal advice means basically those are talking about rights, liability, obligation, remedies of a client lah. Either private law or public law or Sharia law or whatever law it is. As long as it involves law, then it's protected. If it does not refer to law, then it should be disclosed lah. Dia bagi advance pun ni macam business ke, investment ke, finance ke, or anything ke. So it has nothing to do with law. So you cannot rely on 126 and 127 lah. Okay, so you must make sure it's a legal professional privilege. Itu dia. And there must be a lawyer present. There must be a lawyer in communication for legal advice privilege to apply, where this is widely defined to include solicitor, barrister, and even foreign lawyer admitted to practice in their home jurisdiction. Sometimes our Malaysian like to engage with foreign lawyers. So those communication also protected lah. As long as engage to lawyers, then it's protected. If you engage with the architect, okay, or engineer or anybody who is not belonging to lawyer punya industry, no need lah. Okay, accountant ke, okay, itu dia. Where the lawyer is not involved with legal advice privilege, okay, where lawyer is not involved, legal advice privilege will not be applied lah. Okay, so there must be lawyer present lah. Itu dia. And 127 said just now, not only lawyers, the clerk, the interpreter, those are working in legal firm, chambering student, attachment student. You also are bound to follow this rule juga lah. Okay, it's not only lawyer per se. We finish legal advice privilege, we move to apa ni? Litigation privilege. Okay. Okay, you boleh tengok ni yang terbakar dekat hospital Sultan Aminah, relevant to our discussion, litigation privilege. So what is litigation privilege? Legal advice privilege, advice given legal on legal nature. Litigation privilege, keyword dah bagi apa? Litigation, litigate. Maknanya you nak bawa kes ni ke mahkamah. Litigation privilege protect confidential written or oral communication between client or lawyer on their hand and the third party on the others. or other document created by, on behalf of the client or his lawyer, which come into existence once litigation is in contemplation or has commenced, and which is for the dominant purpose of the use in the litigation. So litigation means, okay, if someone is, it's not only between lawyer and the client, but it could include third party. For someone who like to prepare a document or report whatsoever which consists opinion from lawyer, from the client, or even a witness. So if this document or report being prepared for litigation purposes, you can rely on litigation privilege lah to protect it from being disclosed to the other party. Okay, that's why bagi tadi gambar Sultan Hospital Sultan Aminah terbakar tu. Selalunya kalau ada kes kemalangan besar-besar macam ni, terbakar ke apa ke, kematian ke, mesti the place will create a document, create a report. They want to launch a report, and inside the report they include so many things lah. If the report being prepared for their internal use, then if the other party would like to refer to it, then it should be disclosed lah. If the report being prepared for litigation purposes, untuk future punya case, ada case-case ke, then they can rely on this protection, on litigation privilege protection. Okay, itu maksud litigation privilege ya. So beza antara legal advice privilege and litigation privilege. Legal advice privilege, as I said, normally is between two parties, lawyers and clients. And this one is not only two parties involved, even third parties. There's a lawyers, there's a client, there's even a witness. They give their information, put it inside the report. Okay, which we need to use for litigation. And for litigation privilege to apply, they must be litigation. Kalau you prepare the thing is not for litigation, then you cannot rely on privilege. But for legal advice privilege, as I said, whether they want to use for litigation or not, is still protected. Itu beza. Okay, legal advice privilege dengan litigation privilege. Okay, ini wajib kena ada litigation. Litigation maksudnya nak bawa kes ke mahkamah. Okay ya. Litigation privilege is a type of immunity given for a certain act and statement taken in connection with the pursuit of litigation. Okay. This rule covers communication with witnesses and their proof of evidence, and is important respecting communication with potential expert witnesses whose opinion may be necessary, but who are not legal advisor. The requirement that the communication must have been made for the purpose, okay, or pending, okay, for litigations lah. And there's need not be a lawyer present. Tak perlu ada lawyer pun kalau nak pun, okay. Litigation is wider than legal advice privilege and can be protect communication with and document prepared by the accountant and non-legal advisor in preparation for, okay, arbitration whatsoever. Unlike legal advice privilege, which require lawyer in communication with or material produced by a non-legal advisor can be also be privileged under English law, where litigation privilege applies. Okay, sometimes there's no need for a lawyer to be present under legal advice privilege. As long the things being prepared for litigation purposes, okay, you can rely on this kind of protection privilege, litigation privilege. What is requirement is that litigation. Okay, litigation is not only litigation, but even for to extent of arbitration in some cases. Litigation must be afoot or into completion. The requirement to use this litigation privilege only apply where litigation or arbitration is afoot or contemplated taking place. Does not have to be greater 50% prospect litigation, but litigation must be more than mere possibility lah. Okay, it's up to the court to decide. Okay, what this document or report being prepared for what? If the other party try to argue it's litigation, then the court will see lah. How much is it true? Okay, sometimes people are bluffing. It's not for litigation at all. So it's up to the court to decide. If more than 50% of the report being prepared for litigation, then they can rely on this privilege. The communication must have litigation as its dominant purpose. For you to use litigation privilege, okay, you must be able to prove to the court that the dominant purpose of preparing this piece of report or document dominantly is for privileges. Dominantly means more than 50%. Okay, kalau ada 100 pages tu, make sure more than 50%. 50 pages is for nak bawa kes ke mahkamah. Okay, di masa akan datang. Itu dia. Okay, dominant purpose test. Tapi dalam legal advice privilege, tak kisahlah dominant ke, sole purpose ke, is still protected forever. The most important part of litigation privilege is that the prospect of litigation should be dominant purpose, not a sole purpose. Okay, dominant purpose dominant. Tak perlu sole. Sole means 100% must be for litigation, but the court make it easier lah for you to use this litigation. The dominant purpose requirement under the advice head of litigation privilege was laid down by the judge in the unreported English case of Hellenic Mutual War Risk Association against Harian. okay, or known as the Sagera punya case, okay. It is unreported English case, okay, the dominant purpose test. The High Court of Australia has adopted a strict sole purpose test in the case of Grant against Downs, 1976, 135 CLR 674. But the court in Australia, and I believe in all Commonwealth country, has moved to dominant purpose test lah. This one is 1976, So nowadays they are more moving to follow English law lah. Okay, Sagera ni, make it less stricter. Okay, dominant purpose test saja. New Zealand has adopted the dominant purpose test, okay, not the sole purpose test, to know whether litigation privilege, this report deserves to rely on litigation privilege or not. So refer the case of Guardian Royal Exchange of New Zealand against Stewart, 1985, 1 New Zealand Law Report 596. In Malaysia, how things go? In Malaysia, you refer to this case lah, D.I. Eng, P, against Dr. Wong Siak Chung and another, 2007, to MLJ 357. What happened in this case? The plaintiff filed for an action for damages against the defendant for medical negligence. So the medical negligence, the defendant have filed a statement of defense resisting the plaintiff claim to compel the expert witness to attend to court to give evidence and also to bring him the medical report. So kalau ada medical negligence ke kebakaran macam hospital Sultan Aminah tu, selalu dia akan buat report tau. Kes-kes samam-nyamam mesti ada, okay. So diorang di ada parti mesti nak apa report-report ni, semua nak tengok apa what actually siapa betul ke negligent, okay. But in this case, the court allowed the application made by defendants. The medical report prepared by the expert witness was at the instant of the first defendant solicitor for use for pending everything litigation. So cannot be disclosed lah. Okay. Defendant filed a statement. So the court reject, okay, the application to have disclosure of this document is protected under litigation privilege because it's clear that dominantly the report being prepared for the purpose, okay, for litigation purposes, contemplation. Itu dia. So interesting. Our Malaysian case, they use the dominant purpose test lah. Okay. We use pending everything litigation. The opinion and medical report prepared by expert was subject to pending or litigation. Defendant therefore was entitled to object of the expert witness to give evidence. Okay. In other words, the report was also prepared by the expert. Okay, for the purpose of litigation. And therefore not obliged to disclose them to each other. Okay, it's protected. What are the limitations? So in that case, in this case, the court used a dominant purpose test. It's not a sole purpose test. It's clear that the application of this case, the court used a dominant purpose test, not a sole purpose test. What are the limitations given for you to use legal professional privilege, legal advice privilege, as well as litigation privilege? So apa dia punya had itu? Tolong refer balik kepada section 126. Ni kena dengar baik-baik, little bit complicated. Okay, di bawah section 126 tu dia ada 1A dengan 1A lah. Okay, tu dengan 1B sama sekali, sorry. So 1A 126 tu we mention that any communication made in furtherance of any illegal purpose, apa-apa komunikasi yang dibuat bagi membolehkan tercapainya apa-apa maksud yang menyalahi undang-undang. Okay, any communication made in furtherance of any legal purpose, okay, any. So in furtherance maksudnya apa? You tengok proviso A dengan B. Tu beza in furtherance yang pasal A ni. A client say to B, an advocate, I have committed forgery and I wish you to defend me. As a defense of man known to be guilty is not a criminal purpose, this communication is protected from disclosure lah. Normal lah. A person will come and see you and and like to seek advice, okay. So it's your duty to protect whatever information given to you. A client say to B, an advocate, I have committed forgery, I wish to defend him. So you defend him lah. So whatever communicate between you and the client should be protected. But you refer to B. A client says to B, an advocate, I wish to obtain possession of property by the use of forged deed, which I request you to sue. So this is different from illustration A and B. A is someone admitted. B is someone asking you to help him to commit crime. Okay, in other words, B is someone asking you to become accomplice, rakan sejenayah. Tu beza A dengan B. B client come with an honest intention for you to give him an assistance, legal assistance. But B, there's no honest intention. Okay. So the client would like to seek your expertise, okay? Okay, to help him, okay, to commit crime. Boleh nampak tak beza A dengan B ni? So kalau B tu means that any communication made in furtherance of illegal purpose, you cannot protect the communication made lah. You must disclose if the court want you to disclose the information later on, or the police. Nampak tak beza dia?
Nampak.
Nampak So A
Nampak.
dengan B itu beza A dengan B. Section 126 1B pula, kalau any facts observed by advocates in the course of employment as such showing that any crime or fraud has been committed since the commencement of employment, you must disclose it. So it's a duty of ethical duty lah, okay? Ethical and the duty of a lawyer. If you notice your client have commit some crime whatsoever, it's your duty to disclose it lah. You cannot rely on this privilege. Kalau you nampak ada client buat salah ke, okay, sepanjang employment tu, you must disclose it. Apa-apa fakta yang diketahui oleh seorang peguam bela dalam perjalanan perkhidmatannya sedemikian yang menunjukkan bahawa satu jenayah atau fraud telah dilakukan sejak dia mula diguna khidmat, so it's not protected under 126 legal professional privilege. You boleh refer kepada kes re-detention of Leonard Teo Hoi Leong 1998, 19 Law Journal, page 157, 100 orang Melayu tukar nama. It's involving murtadnya kes lah. There's a lady here by the name of, if I'm not mistaken, is Nur Aisyah binti Buhari. So she would like to get married with one Catholic guy. Okay, instead of the guy converting to Islam, she convert to the religion belonging to the guy lah, which happened to be a Christian Catholic. So the father objected, Nur Aisyah binti Buhari. Okay, Buhari objected lah. Okay, but they eloped lah, kahwin lari. So before kahwin lari, okay, this Aisyah made a lawyer. Ni lah, Leonard Teo Hoi Leong, asking him to change the religion lah, tukar nama. So from Nur Aisyah binti Buhari become a new religion, Aisyah Felicia Buhari. Okay, from Nur Aisyah Buhari become Aisyah Felicia binti Buhari. Sedap tak nama dia? Aisyah Felicia. Okay, okay. Aisyah Felicia, okay, from Nur Aisyah jadi become Aisyah Felicia, sorry. Okay, so they get married afterward lah. So the father, Mr. Buhari, not happy. They lodge a police report lah, okay, about kidnapping, so this thing. The police investigate, and during the investigation, they meet this lawyer lah, Leonard Teo Hoi Leong, and ask the lawyer about the whereabouts of this Nur Aisyah and the boyfriend. But this lawyer, they want to disclose. They said it's 126, whatever been conveyed between me and my client is protected, legal professional privilege. But in this case, it's being rejected lah. The idea of a legal professional privilege being rejected. Why? Because number one is you cannot use this because they are police are doing investigation of a crime. This lawyer is no longer a lawyer. He become a suspect. Okay. Okay, you are no longer a lawyer. Okay, like a suspect. So suspect, you are not protected. You must disclose the information. You are no longer a lawyer. You cannot use legal professional privilege. And plus, if you're a lawyer also, you cannot protect the information. Okay, if your client commit crime, in furtherance of commit crimes. Okay, itu dah. Okay, section 126 A itu. Okay, you cannot protect. Itu sebab dia, you must disclose lah. In this case, the lawyer, Leonard Teo Hoi Leong, failed to use the legal professional privilege lah to protect the communication. He must disclose whatever been conveyed to him from Nur Aisyah or aka Aisyah Felicia to him. Okay, when she asked for assistance from this lawyer. Okay, this would be the argument being raised in this particular case lah. Okay, and next, okay, the communication made between Mr. Leonard Teo Hoi Leong and Nur Aisyah were no longer privileged. Okay, so this is a criminal investigation. Okay, the lawyer is no longer a lawyer but become one of the suspect. Okay, so that's why you cannot rely on section 126 legal professional privilege. The privilege is gone from you, so you must disclose the communication made to you lah. Okay, Nur Aisyah become Aisyah Felicia. Okay, question: who can waive legal professional privilege? Waive means bye-bye. Okay, waive means what? Allow you, okay, to disclose the communication lah. You refer case of Dato' Aubachi against Koh Keng Keng, 1989, 3 Milan Law Journal, 445. As mentioned under 126 just now, express client consent. There must be express client consent. Okay, itu dia. Kalau tak ada express client consent, then cannot. Okay, implied boleh tak sir? Tak boleh. Communication continue even your client dead. Okay, kalau dia sudah meninggal pun, client meninggal pun, this communication is still protected tau. That's the rule. Okay, unless there's an express consent, there's a must clear persetujuan nyata under section 126 mentioned just now. The issue pertaining to secondary evidence, how the privilege can lost through the process of copying. This what happen, you can see the photo dia, kenapa muncul penjenayah ni. Mana tahu kan kita lawyer-lawyer ni kadang-kadang ada orang tak suka kita. Okay. Mana tahu ada malam-malam kan ada orang masuk ke pejabat firm kita, dia tak nak curi, dia very smart, dia tak buat, dia tak curi dokumen tapi dia fotokopi. Dia guna mesin pejabat kita buat fotokopi, dokumen tu dia guna untuk hantam kita balik dalam mahkamah. Anything possible nowadays. The issue, does the privilege protected the original document only or protected the original as well as the photocopy, the secondary? Which one? Primary only or secondary also? Okay, that's the idea about this issue lah. You refer case Calcraft against Guest, 1898, 1 Queen Bench, 759. It's clearly that, mentioned that, if someone make a photocopy of the legal document, even by still, the privilege under section 106 cannot be used against the stolen legal document. Sorry to say. So you must lock your office door clearly, okay, very strongly. Okay, someone steal it, okay, they want to use it against you in court, you cannot rely on communication privilege. Okay, the other party can disclose it, okay, against you in court. Ingat tak last semester kita belajar illegally obtained evidence? The court is not bother how the evidence is obtained as long it is relevant. Kurma. This is the implication. Tak adil lah sir, memang tak adil. Okay, that's why you can refer to the case of Lord Ashburton against Pape 1913 to Chancery 469. Kalau you notice someone bring in into your document, make a photocopy, you must immediately go to court, apply for injunction to prevent the document, the photocopy document from being disclosed. Okay, once the document being disclosed in court, then you are too late. Okay, itu dia. Okay, you still have right to ask for injunction lah, to prevent the document from being disclosed in court. Okay, but you must do it quickly. Once the document being disclosed in court, then you are too late. Okay, itulah dia. So we finish legal professional privilege. Next week we discuss state privilege, crown privilege, executive privilege or public interest immunity privilege. Dokumen milik kerajaan, OSA, Official Secret Act. Yes. Any question? Okay.
Sir, saya ada soalan sir.
Yes, Wafi.
Okay, kalau bawah profesor tu dia cakap kena proofkan in furtherance of a crime ataupun yang since his employment dah ada crime kan, betul tak? Okay, kita kena buktikan crime tu, kita kena buktikan dulu ke ataupun ada speculation? Kalau nak dan soalan kedua, kalau kena buktikan dia pakai BOP apa? Balance of probabilities ke beyond reasonable doubt?
Kalau crime tu answer question number 2 dulu lah. Apa kalau crime tu memang clear lah, is BRD lah, beyond reasonable of doubt, not BOP.
So kita kena proofkan orang tu, kita kena establishkan orang tu dah fulfill element of crime tu beyond reasonable doubt, baru kita boleh bagi exception kepada professional privilege lah.
Because it's a duty of a lawyer, Wafi, because we don't know, sometimes we are not so sure whether the person is guilty or not. A client yang come and see us, macam tu je dia bagi client, a layman, dia bukan tahu undang-undang pun macam kita ni, actors reus, mens rea, what on earth is that? Okay, itu dia. Okay, so it's a duty lah, okay, on our part of ours is to protect our client, okay, even though we know that the person is truly guilty, tapi as a lawyer kan kita dah belajar dulu kan, okay, the person might commit a crime, but he might not do it based on intention lah. Okay, itulah dia. So whatever it is if a client can come and seek help from us, it's our duty to protect them. Okay. Itu.
So maknanya sir memang kena establish dululah, baru kita boleh invoke exception tu.
Kita kena apply legal professional privilege tu automatically. Okay. Itu maksud dia.
Saya faham. Maksudnya macam contohnya lah, ada lawyer ni, dia bagi tahulah dekat court, klien dia ada buat jenayah. Sebab dia nak pakai exception tu lah. Dia kata dia tak protected, bahawa dia tak bind kepada legal professional privilege sebab dia jatuh bawah exception tu.
Okay.
So lawyer tu, dia kena establish yang klien dia dah buat crime tu melalui beyond reasonable doubt dulu baru dia boleh guna exception ataupun faham maksud saya?
Okay, lawyer tu dia nak pakai exception tu. Okay, nak kena
exception
establish
tu.
dulu ke tak? Tak perlulah.
Tu macam mana dia nak pakai, dia hanya boleh cakap
This is
spekulasi
clear. It is a halal punya communication lah. It's a legal kind of communication. Normally being given from a lawyer to client to lawyer. So they can invoke section 126 immediately.
Maksud saya macam ni saya.
Tak perlu proof orang tu dah. Sebab communication dia is a bona fide communication between sama ada orang tu buat jenayah ke tidak ke, is still protected.
Ya saya, tapi itu yang maksud saya cakap, kalau dia nak accept, nak mengecualikan diri dia daripada terikat dengan solicitor client privilege ni, contohnya dia disclose lah yang klien dia ada buat crime, sebab klien dia datang kat dia, so dia kena buktikan dekat court ke yang klien saya dah buat crime, ini bukti-bukti sekalian, dan bukti tu kalau kena buktikan, bukti tu kena based on beyond reasonable doubt ke, ataupun macam cakap dekat court kita ada enough proof yang cakap dia buat. Faham maksud saya? Saya tak salah saya.
Okay, bukti apa bukti, apa kuantum dia semua, bla 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 bla. Okay lah, for me, as long as fulfill the requirement needed under 126, okay lah. If does not fulfill under 126, then dia tak boleh pakai lah. That would be my answer to your question. Itu je, fulfilling the requirement. Okay.
Yelah, maknanya dia tak perlukan bukti secara total lah bahawa orang tu dah buat crime, baru dia boleh pakai exception.
Dia tak perlulah, dah habis tu baru pakai exception ke apa ke.
Sebab saya ingat macam contohnya dia ngaku kat orang, dekat lawyer tu dia buat murder. Lepas tu lawyer tu kalau nak guna exception tu kena buktikan dekat court yang dia ni dah buat murder, dan cara buktikan tu beyond reasonable doubt, baru dia boleh pakai exception tu. So maknanya exception tu tak strict lah.
Asalkan it's a halal punya communication, it's a clear cut bona fide communication between client and lawyer, is not protected lah. Only court as mentioned tadi, proviso A dengan B tu, kalau dia ada in furtherance of any illegal activities, or if the lawyer notice anything which is illegal done by the lawyer, then it's not protected.
Faham. Okay. Thank you, sir.
That would be my understanding. Okay, law is a developing process. It could be someone have a different view. That would be my view lah, Wafi. Okay. Other people might have their own view. Okay. Tapi so far within the NBO 126 A dengan B, itulah yang dia mention. In furtherance maksudnya future tense. Yang B itu pula, if you notice now, is a present tense. Okay.
Present
yang
tense
proviso
daripada employment dia.
Is more on previous past tense. Okay. So past, present dan future tense kena bezakan.
Okay. Yang pakai adalah present dengan future kan?
Yang tak terpakai tu maknanya kena disclose is a future dengan present.
Okay, faham. So maknanya dia tak perlu macam bersungguh-sungguh cakap dekat court, saya ada bukti yang dia betul-betul nak buat, macam establishkan semua elemen, tak perlulah.
Tak perlu.
Bona fide punya communication je.
Just follow requirement 126 tu aje.
Okay,
In furtherance, you're most welcome. In furtherance or not, tu aje.
Okay.
Any more question?
Saya nak tanya.
Ya tanyalah.
Saya tanya dulu
Tanya.
Kalau section 23 Evidence Act, dia cakap kat situ kiranya kita boleh bagi ke segala communication kita dengan klien kita dekat court?
Section berapa?
Section 23.
Ini last semester. Ini apa? Is a without prejudice communication privilege. So whatever being agreed upon during the arbitration process, mediation process, negotiation process cannot be disclosed in court lah. It's protected under without prejudice communication under section 123. Last semester we have learned, right? Okay. Without prejudice communication, section 23. It's protected. Yes. Is it okay, Syatra?
Okay. Okay, thank you, sir.
You're most welcome. Any question more?
Sir,
Ya.
saya nak tanya tentang litigation privilege.
Apa benda? Litigation privilege. Okey.
Litigation privilege kan communication between lawyer, client and third party kan? Third party tu kira witness ke?
It can be witness, it can be expert witness. Macam kes dek Dr. Wong dia tu, kan ada expert witness. Okay. So lawyer is not a must lah. It's not necessary for lawyer to present. Okay. For legal advice privilege, lawyer is a must lah because between client and lawyer, right? Okay. But for litigation is things means macam reports, documents, whatever it is being prepared for litigation. Syarat dia litigation purpose. You nak bawa benda ni, maksudnya document or report for litigation, nak bawa masuk ke mahkamah. Okay. So asalkan you able to convince the court that this thing going to for litigation purposes, then you are entitled to rely on this privilege. Itu maksud dia. Boleh faham Dayana?
Okay. Thank you, sir.
So third party can be witness, can be expert witness, can be anybody, a client or whoever. Okay?
Okay.
Any more question?
So there's question dekat chat.
I nak yang verbal ni dulu, chat nanti. Add here, mic function. Abdul Had, important of privilege of communication to ensure strategy plan by lawyer not being disclosed. Okay. So I have question, Imran. Okay. Is there any implied waiver of this privilege in law? And if there's any, how the court treats, there's no implied waiver. Imran tak ada implied waiver, Imran. Dia Imran. Sekejap ya. Ni kat chat ni, dia Imran. For the time being, no implied waiver. Okay. Thank you, Abdul Had. Any question?
Sir?
Yep.
Saya masih kurang jelas dengan yang yang bawah B tadi.
Yang bawah B tadi?
Ya. Kalau yang tu kan, siapa yang buat fraud dengan tu? Sama ada lawyer ataupun klien tu sendiri yang buat fraud tu. Saya masih kurang jelas antara tu.
Yang mana? Yang section 126?
126 B.
Illustration A dengan B ke proviso A dengan B? Dua ni.
Proviso B.
Yang ni. Section 126 1B. Any facts observed by the advocate in the course of his employment as such showing that any crime or fraud has been committed since the commence of. Yang ini kalau yang klien tu kalau dia ada buat kesalahan. Lawyer tu notice klien. Kita kan kadang-kadang klien datang kita macam-macam jenis klien manusia yang ada ni tu. Okey, Fauzan So kalau klien tu kalau kita perasan dia ada involve dengan jenayah ke apa. So it's our duty lah, okay, to disclose it. We cannot rely on privilege to protect crime. Okay.
I see.
Masa dia kita employment kita throughout our employment tu maksud dia B ni. Okay, commencements of the employment. Yang tadi saya cakap dengan Wafi tu, okay, present. Okay. Yang 1A tu future. Okay, ini present. Kalau kita perasan, kalau kita tahu klien aku ni ada done something wrong, klien aku ni dia tak bayar cukai. You notice. So maknanya is your obligation to disclose it when the time need arise. You cannot rely on this privilege. Okay, itu maksud dia Fauzan.
Okay, sir.
You tak boleh bersekongkol dengan you punya client untuk melakukan jenayah. Okay. Okay. If not, okay, kalau susah, kalau tak nanti then you breach your ethical punya rule lah. Okay. Ada implication kalau orang tahu, kalau ada staff tahu, dia buat report dekat majlis peguam, habis you punya ada nanti inquiry, domestic inquiry, then severe implication will be you punya license kena suspend atau tarik terus. Maknanya you tak boleh practice. Buat selama-lamanya.
Okay, sir.
Itu maksud dia Fauzan. Okay, thank you Fauzan. You're most welcome Fauzan.
Sir nak tanya.
Ya, tanya.
Kiranya kalau in that situation, it also involves bila kalau client tu suruh lawyer dia accuse another person of the crime that he has committed ke?
Apa dia lawyer dia accuse another person what?
The client
Hmm?
ask his lawyer to
Okay.
accuse another person or to macam tell the court that the client admitted that he has done the crime, but
Okay,
then
okay.
But then he asked his lawyer to accuse another person to tell the court that another person did the crime. Kalau macam tu, will it be considered under Proviso B tu?
No, no, it's not Proviso A, it's not Proviso B, Raihana. For me, it's very simple. It's just a comment. It's something which it's just a normal confession being made by anybody lah. I've done this crime. Okay, I've done this crime together with this person. It's not only legal, but also it is admissible, right? We have learned last semester, section 32, confession which led to another accused. Okay. Okay, it's possible also under corroboration rule we have learned about corroboration, extra evidence to support. So for me, it's not caught under A and B.
Oh, so
Okay,
kiranya
A and
that
B is a more pure kind of crime though. It's a very clear kind of crime. If a client come and see you say that I have committed this crime, okay, not only me alone, together with this guy, that guy, it's a normal thing. Okay. Okay. It's a normal thing, okay. So communication should be protected lah. Okay. It's for Proviso A and B is more like a more serious kind of a crime lah. Okay, you are asking a lawyer to become an accomplice with you. Okay, more like that. Okay, Proviso A itu is more a very serious crime tau. Dia nak suruh lawyer tu bersekongkol dengan dia untuk melakukan jenayah lagi. Okay, dear lawyer, can you help me to rob this bank? Habis. Okay. Oh, dear lawyer, how I can avoid myself from paying zakat or paying income tax to Malaysian government? That was a clear kind of crime. Okay.
Okay.
Itu beza dia. I hope you understand, Raihana, yang A dengan B.
So kiranya that type of communication is protected lah kan under this privilege.
What you mentioned to me just now is still protected because to me it's something which is normal communication between client and lawyer.
If for instance in order for the lawyer to accuse another person, he commits fraud or forgery, will it be
He
under
accuse other people of committing fraud and forgery, yeah?
No. He accused another person by the lawyer committing fraud or forgery.
Apa dia accuse the lawyer?
The lawyer nak accuse another person. So by way of him accusing another person, he commits fraud or forgery, then will it be considered under Proviso B tu?
Kalau it depends on what you put it. If he's caught under B, you can caught under B. If managed not caught under B, it's not caught under B lah. It all depends.
Okay.
Okay, if the commission of crime is being committed beforehand in front of you, then it's certainly being caught under B.
Okay.
If it's not being committed in front of you in furtherance or currently, okay, past tense or future tense, okay, it's something which is committed in the past, okay, then it's a duty of every lawyer, okay, which need to protect the client. Okay.
So if it's just the client asking him to do, it's only communication lah kan?
It's a communication. It all depends. Okay, how they communicate. What is the idea of communication? What kind of the communication being conveyed lah?
Okay.
Okay. So I want you to help me to commit fraud. I want you to help me to commit fraud. Means that future punya crime kan? That one is not caught lah.
Okay.
Okay. Okay. I want you to defend me for the fraud I have committed. For the fraud I have committed. It's a confession. Okay. Okay. So it's protected. Okay. So future and the past, you must able to differentiate it.
Okay. All right. Thank you, sir.
You're most welcome. And this one I taught you is only general principle tau, under 126 ni. Dia banyak lagi tiny things about rule of ethical of a lawyer and clients. Okay, you're going to learn later on lah during the final year. under the professional practice punya subjek. Ini hanya portion of it Jangan ingat ini segala-galanya Banyak lagi. Okay. There's so many kind of things you can do and cannot do with your clients. Okay. And the clients can do towards you also. Dia macam doktor jugalah. Dia ada rules of ethics tu. You're going to learn later on. Ini in terms of evidence saja. Okay. How much the evidence can be get from your clients, from your lawyer, okay, in court. Okay, it's only protected legal advice communication and legal litigation privileges communication. Itu dia. Any more question? Ada soalan lagi ke? Siapa-siapa? Berapa orang datang ini? Yeah. So far it's 42 Okay. Syami faham ke Syami?
Faham doktor.
Clear Syami Kat mana ni? Usim ke?
Rumah lagi. Rumah.
Kat rumah
lagi. Kat rumah.
Sihat Syami?
Sihat. Alhamdulillah sihat. Doktor sihat?
Boleh lah. Boleh. Syami dah potong rambut I.
Betul lah.
Tak pakai topi ni. Yang lain semua okey. Tadi siapa-siapa lagi tanya? Filza okey Filza Hendun.
Okey doktor.
Okey Siapa seorang lagi tu? Okey. Suhaili Arham ada? Arham okey Arham?
Okay, sir.
Okay. That's good. Akmal okay? Wan Mama Akmal okay?
Hi, sir. Okay, sir.
Hi. Okay. Jarif Aiman okay? Jarif Aiman bin Sazali. Okay ke? Suara tak dengar. Suara tak dengar. Nampak you tekan button tu tapi suara tak dengar. Okay. Jadi okey ya. Mana ni? Okey lah, tak ada semua okey ya. Okey, dah pukul berapa ni? 12 tepat. That's good question Thank you very much for the question Very good question. I like it very much. Banyak benda tu So berhati-hati kalau buka firm nanti make sure itu selalu firm dia punya mangga tu besar-besar. Sebab ni lah case ni, car craft ni. Someone can come to your firm, make photocopy, the photocopy privilege not cover. Okay. Can be disclosed itu. So you nak protect it, follow Lord Ashburton against Pip punya case you kena apply to injunction from the court from disclosure of this document Yang Arif ada orang masuk dalam firm saya. They make a photocopy of the document, we notice. Okay. Okay, so we want to make sure this document being protected from disclosure in court. Okay. Kena cepat-cepat. So next week kita bincang state privilege public good reminder kita punya take home test next week lah kan 14-21 nanti saya disclose lah question simple question je mudah je so I bagi 1 minggu jawab soalan so Syami nanti kutip lah okay taruh dalam folder satu untuk midterm take home test satu lagi untuk assignment siapa dah siap boleh hantar pada Syami
okay
nanti Syami kutip lah assignment individual lah bukan group
Sir
ya
ada Word document ke PDF?
Up to you lah. Terpulang kepada anda. PDF pun boleh, Word pun boleh. Yang penting hantar.
Alright, thank you.
Sekejap, PDF ke Word yang mana satu baik kita confirm betul. Tak apalah, I rasa bagi Word lah sister Senang nak tulis markah kat situ terus. Okay lah everybody, thank you for question sister, very good question. Word. Okay. Hantar dalam Microsoft Word Kenapa? Sebab senang saya nak tulis markah. Word okay tak? Word okay? Okay.
Okay.
Saya risau kalau guna Word, dia punya format lari.
Kau takut hilang format lari boleh berlaku
Dia boleh berlaku lah. Sebab kadang contoh ada certain student dia guna Microsoft Word 2000 lain. Lepas tu bila download jadi 2000 lain. So dia akan lari sikit dari segi formatting tu semua lah.
So tak pasal kena potong makan hanya sebab format lari. Okay lah Syami, raise a very good point lah. Thank you Syami. Okay lah, PDF lah. Word pun boleh, PDF pun boleh lah. Terpulang pada masing-masing. Okay, terpulang tuan. PDF pun boleh, Word pun boleh. Okay. Okay, reminder again, please come for our first virtual talk. Okay, make sure you have Gmail email address before using Google Meet. Just press the button, okay, for those who are using laptop, or you can scan dekat poster ni aja. I dah try dia pakai komputer, smartphone pun boleh juga. So Khamis ni pukul 2 sampai 3 So if you have any question like to ask Tuan Fazaluddin about anything about evidence, syariah or civil, by all means tanyalah. Okay, this is the opportunity So Syami said Google Meet kita boleh pakai more than 1 hour. So nak tanya soalan sampai petang pun boleh. Pukul 2 sampai pukul 5. Hopefully tak payahlah. Okay, itulah Tuan Fazaluddin rajin bercakap ni. So mungkin panjang lah. Okay, itulah dia. So Syami tengok-tengok kan Syami. Pray for the best Syami
InsyaAllah.
Okay. Hai, seksonnya. Cubalah, first time. Okay, thank you very much. Thank you very much everybody for your participation. I will try to produce formal letter appointment as soon as possible. So saya sudah dapat nama Siti Fatin Hanis binti Romi, Nur Akila Syuhada Zulkifli Eliana Fatin bin Ahmad, Syauqi Mardia bin Bahagia. Apa dia? Anything Syami? Tak ada. Putus-putus suara you. Okay. Ashraf bin Abu Bakar, okay, Muhammad apa tu? Faiz Ashraf tu dia. So thank you so much Syami, I need your help. Boleh tak you ask anybody to prepare the poster like this one for this person? 6 individual. Syami boleh
Okay, alright.
So ini guideline poster lah. Make it something different lah. Tengok macam sama je. Ada gambar mereka email, communication, nombor handphone kalau apa-apa hal nak tampal dekat legal clinic tu. So nanti LPQB datang tengok, wow, okay activities, okay so nanti you bagilah poster by next week ke or week after that Syami. Okay, thank you very much everybody for your participation for today's talk. Hope to see everybody for our virtual special talk this coming Thursday evening So I think that's all. Thank you very much and stay safe. Okay, thank you. Assalamualaikum.
Waalaikumsalam.
Rambut sudah pendek.
Bye.
Thank you Syarif. Bye.